right. Human beings. Yes, this is what people do, and then they wander, but I'm going to speak here so I don't have to be mic'd.
Am I mic'd now as I talk so they can hear me?
I don't think so. I think they're going to probably wait until...
Or no, but what I'm saying is, does he turn that on from here?
Why don't you run up and ask him? Everyone, it is my pleasure today to introduce Brandt Goldstein, who's here to talk about his recently published book, Storming the Court. Mr. Goldstein graduated from Yale Law School in 1992. He clerked for Judge Harry Edwards and then worked as an associate for Cleary, Gottlieb, Steen, and Hamilton for 4 years before quitting law practice to begin work on this book. I know Brandt personally, as I had the pleasure of clerking with him for Judge Edwards, and in a profession known for its perfectionists, and in the chambers of a judge who is particularly known as a perfectionist, Brandt earned himself the reputation of being the most perfectionist of us all, particularly when it came to his writing. And I recall feeling distinctly envious when I would notice that the judge often gave Brandt the assignment to write his speech, whereas I was toiling away on thrilling things like bench memos. Well, we are all now the beneficiaries of Brandt's perfectionism. The book he has written has been praised for being meticulously researched, but more importantly, at least to this legal writing instructor, it is written in a clear, crisp, and elegant style. And so not only is it an important and inspiring story that he's telling, but more than that, it's a really great read, and I recommend it highly. So welcome, Mr. Goldstein.
Thank you very much, and thank you, Professor Ludington. And thank you also to the program in public law and Professor Chris Schrader and to Duke Law School for giving me the opportunity to speak today. My book, Storming the Court, is a story about people like you. It is the true story of a group of law students who took 2 United States presidents to court to free a band of innocent political refugees on Guantanamo 12 years ago. If I've done my job right, what I've written is a human rights courtroom drama, a tale of passionate idealists who set out to hold this country to its highest principles, and the collision between those principles and the often harsh worlds of the courts and the political arena. What I want to do is tell you a bit about the story today, and then about the challenges of writing it, and finish up with some thoughts about Guantanamo in its current state. So first to the story. The year is 1990, and we are in the country of Haiti, with a 28-year-old democracy activist named Pascal. She is the mother of 2 young children and the wife of a high-level political dissident. And Haiti, as you probably know, is a country of great poverty. And it is labored under brutal dictatorial rule for most of its 200-year history. But 1990 is a great year for Haiti. Why? The first democratically elected president in the country's history, Jean-Bertrand Aristide, takes office in early 1991. And people like Pascal, who have thrown her life into working for him, have great hope that he will do 2 things for the country. First, narrow the gap in wealth between the 100 hugely rich families that basically control the entire country and the rest of the 5 or 6 million people who live in miserable poverty, including Yvonne and her family, a 3-room shanty in Cité Soleil, a sprawling slum in Port-au-Prince. They don't even have running water. Second, rein in a brutal military whose primary occupation in its 100-year history has been to terrorize its own citizens. The rich and the military do not like Jean-Bertrand Aristide very much. And 9 months after he is brought to power, he is ousted in a vicious military coup. What happens to people like Pascal and her husband, Antonin Joseph? As a high-level dissident, he has to go into hiding immediately. She goes back to the 3-room shanty where she stays with her 2 children. She's cranking out pro-Aristide leaflets one night on a second-hand typewriter, tap, 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 and bam, the door is knocked down. 6 soldiers burst into the room and begin beating her in front of her children. They drag her away. They take her to a police prison in downtown Port-au-Prince, where she is tortured by being beaten with rifle butts and having lit cigarettes put out on her arm in an attempt to get her to reveal the location of her husband. She doesn't talk. They keep beating her to the point that she passes out and miscarries on the floor of her cell. Miraculously, they let her go, and she decides she has no choice. She puts her children in safekeeping with her mother, and she flees, along with thousands of other democracy activists just like herself. They get into rickety boats and take off in the middle of the night and pour into the Windward Passage between Haiti and Cuba. And this is 1991 now, and the Bush administration has ordered that Coast Guard cutters intercept all of the boats and bring everyone on board to a place that everyone here knows very well today, Guantanamo Bay. There, federal immigration officials are waiting for people like Yvonne Pascal, and they have one task in mind. They interview each person, and they are trying to determine whether or not they are a political refugee, somebody who has a well-founded fear of persecution, and therefore, were they to be returned to Haiti, they might well be killed, or be merely an economic migrant, in which case we can send them straight back to the arms of the Haitian military in Port-au-Prince, and no further process. We let about 8,000 to 10,000 people into this country through the interview process, sent 25,000 back. But for Yvonne Pascal and 300 other innocent men, women, and children, there was a different fate entirely. Yvonne went through her immigration interview. She proved that she deserved asylum in this country, and then she tested positive for HIV. It's 1992, a period of great fear, even hysteria about AIDS in this country. Little kids will test positive for the disease, and their family will be drummed out of a small town. People who are suspected of having AIDS are kicked out of their jobs or their apartments. And we let this attitude affect how we treat these 300 innocent men, women, and children. There is a federal regulation that bars people who are HIV positive from coming into this country. We never, ever enforce it, just about. Millions of people come into the country every year legally. We don't test them positive for HIV. If even 0.5% of them have it, then tens of thousands of people cross our borders with it every year. But do we worry about them? No. Instead, we focus on 300 innocent men, women, and children being held on Guantanamo who have fled a brutal dictator in our own backyard. We surround them with razor wire, we put up guard towers, and we create, in the early months of 1992, America's first HIV detention camp. The Public Health Service gets wind of what's going on, and they immediately contact federal immigration officials. Shut this camp down. This is insanity. You are taking immunocompromised people and cramming them into leaky barracks. You have no proper running water near the latrine facilities, which are nothing but those porta potties you see at football games. This is a disaster. No response from the INS. No response from federal immigration officials. And does the United States military want this job? No. No. Our men and women in uniform are supposed to protect this country, not run a refugee camp. Once again, no response from immigration in the Department of Justice. So, I'm going to leave Yvonne Pascal and the other men, women, and children on Guantanamo for a moment and take you to a place you know a lot better. Law school. Law school. It's March 1992 in New Haven, Connecticut, and a bunch of law students, people just like you, are watching what's going on. They're keeping track of it in the newspaper. A little bit of cultural context. Silence of the Lambs is about to win Best Picture. Nirvana is taking over the radio, and there is no internet. There is no internet. So what people are doing is studying this case through the everyday, ordinary, comes-to-your-door newspaper. The students bring different concerns to the situation. Some of them really appreciate the fact that people are trying to bring democracy to Haiti. Others remember the story of the St. Louis. Does anybody here know the story of the steamship St. Louis? Yes. We should tell people very quickly.
There were Jewish refugees that were trying to get away from Europe during
Right.
the rise of Hitler, and they came all the way over to us, and then we sent them back, and they were dispersed through European countries, which were later taken over by Hitler.
That's exactly right. You're too good. You could do this. This is an incredible an episode of great shame for our country. 1939, just before World War II, a steamship carrying 937 German Jews arrives on our shores. Miami Harbor. What do? They're fleeing the Nazi regime. We send them back. And a number of them end up dying in the Nazi gas chambers. You can read about it in a book called Voyage of the Damned. So this is also on the students' minds. And they think, with their various different concerns, you know what? The way we're treating the Haitians is not what our country stands for. It's not what our flag stands for. It's not what the Constitution stands for. And they come up with a crazy idea. Why don't we file a lawsuit on behalf of them? Now, they can't do it alone, right? Because they don't have their JDs, they haven't passed the bar, they can't even file the pleadings and sign them. But what they do is they go to an international law professor, a 37-year-old professor named Harold Koh, the son of political refugees from Korea, South Korea. And they raise this idea with him. What does Harold think? Well, he's run an international human rights clinic before, and he's sued military thugs from places like Guatemala who don't show up in court. But this is different, you know, a completely different ball of wax. He thinks they're crazy. They're nuts, right? You want to sue the United States Department of Justice. You want to take on the biggest litigation machine in the world with tens of thousands of lawyers, endless resources, and a client in the form of the White House that is never going to yield. What's more, you're talking about a United States Coast Guard cutter operation in the Caribbean, a U.S. naval base 1,500 miles away, and your clients, your potential clients, are being held incommunicado and speak a language that you don't know. Forget it. Forget it, right? But something happens. He thinks he's seen the last of them, and 2 days later, a legal memo appears under his door. Then 2, then 4, then 6. Their law review articles have been Xeroxed and highlighted. The same with cases. His voicemail box is packed, and there are little Post-its stuck all over his door. And he begins to think, I have a huge horde of students willing to help me. I have students willing to do legal research, students willing to write briefs, students willing to blue book, site check, proofread, manage document discovery, set up depositions, do anything necessary to file this case. And it also makes him think about his own legacy. He is here in this country. His father was a political refugee from South Korea who had stood up and fought for democracy in his own country and ended up exiled here at the age of 40 because of it. The reason Harold's family is here because of the same laws that are now at stake. And so, amazingly, just 3 weeks from the day that the students first approached him, this group of people ends up in the United States District Court for the Eastern District of New York in Brooklyn and files for a TRO seeking access to their Haitian clients. What does the government do? United States Justice, the Department of Justice, the lawyers sweep into court and they instantly say, dismiss this case. No legal leg to stand on, 12b-6, right? Why? This ought to sound familiar to everybody in this room. Because the Constitution of the United States does not apply on Guantanamo Bay. Because no other federal law applies on Guantanamo Bay. We can do whatever we want to these people. We can be arbitrary, capricious, or even cruel. And that is a quote in the court record. And they can't do anything about it because they have no rights. And there's more. There's more. Then the Justice Department files a Rule 11 sanctions motion against Koh and Yale for bringing a frivolous lawsuit. Unbelievable. The students go back with Koh to New Haven now. It's Friday evening, the tail end of spring break, and they are in a world of hurt. They have 3 days to respond to a government motion, memo, and exhibits the size of a phone book. What are they going to do? They all pour into Harold's living room. They got their backpacks, they got their Coke, they got their legal pads, and they are ready for a fight. Their attitude is simple. We don't know the stuff the way the Department of Justice does, but we can study it, we can learn it, we can outwork them, and we can at least survive the motion to dismiss. So they divide up the brief into little tiny pieces, little bite-sized chunks, and everyone's got those little bendy computer disks from like 1992, and they go off into the New Haven night and they get to work. And over the next 3 days, nonstop, they each take their little piece, and Friday or Monday at around noon, they stitch it all together into one brief, and they race down to Brooklyn and file it a minute before it's due. And Judge Sterling Johnson, Jr., of the United States District Court for the Eastern District of New York, a Bush appointee who has only been on the bench for 6 months, a former Marine who has served on Guantanamo, issues the TRO in favor of the students and co. And over the strenuous objections of the government, 2 days later, Mike Wishney, Yale Law School class of 1993, and his classmates and several human rights lawyers are on their way to Guantanamo in a C-130 transport plane in the pre-dawn darkness to meet with their clients. And that is the way this book begins. Those are basically the first 3 chapters. So if you read it, you can just go straight to chapter 4. I learned about this case because my law school classmates brought it. And both Professor Coe and some of my classmates asked me to work on it with them. I was deeply involved in a project with the homeless, and I knew that I could never finish it and graduate if I worked on the case. But it ate at me, and I knew something big was going on. I recall my friend Ray Brescia running down the hallway, all pasty-faced, dark circles under his eyes, legal research trailing behind him. And the next day, there'd be something about the case in the New York Times on the front page. It ate at me, it stuck with me, and 7 years after I first heard about it, I started work on it. And I left the law to write full time. And I thought this story was so important, I probably could have written law review articles about it, or maybe a big public policy study. I didn't want to do that. I wanted to write a narrative that would be accessible to the lay reader, someone other than just a lawyer or a policymaker or people in government. So I took as my models A Civil Action and In Cold Blood by Truman Capote. And I set out to write an engaging and absorbing narrative that would grab you from the first page, at least I hoped. I had a whole bunch of challenges. What was the first one? Big, complicated lawsuit. The White House, Congress, the Supreme Court, foreign policy, the Administrative Procedure Act, Racejudicata, plain meaning and statutory interpretation, on and on and on. Bore the reader to tears. I can't afford to do that. So I boil everything down to one basic issue, one that I've already raised with you today. Does the Constitution apply on Guantanamo Bay, or does it not? Because if the Due Process Clause applies, then you cannot treat Yvonne Pascal like an animal. She has access to a lawyer. You have to give her proper medical care, and you can't hold her indefinitely without charge. So that's the legal issue that drives the story. But what's more important than that? The characters. The characters. Who am I going to write about? Law students. Tori Clausen. She's a first year. She just finished college in Hartford, Connecticut. She wants to be a human rights lawyer, but she really doesn't even know what that means. She's bored by her classes. She's intimidated by her professors. She doesn't like the reading. She's not even sure she should come to law school. And then one day, she sees this sign on the wall, hastily written out, emergency meeting on behalf of Haitians held on Guantanamo. She'd never even heard of Guantanamo. She goes to the meeting, and her life changes. Her life changes. Who's she most inspired by? A third-year law student named Lisa Dugard, unbelievably talented. Went to college after 6th grade. Graduated in 4 years from the University of Washington at Seattle with a degree in history and went to Cornell, where she got a PhD, everything but her dissertation, and arrived at Yale at age 23 with she might have had a bullhorn in one hand and her fist raised. And Lisa, what made her special, it wasn't her intelligence, it was her passion, it was her activism, it was her commitment. When she was 4 years old, her dad wanted to cut down the cottonwood trees in their backyard in Seattle. She protested by tying herself and her 2-year-old sister to the tree trunks. And the trees still stand today. This group of students drove each other, and they drove Harold Coe. They missed class, they missed job interviews. Some of them didn't even graduate on time and had to skip out on their own graduation ceremonies for the sake of this case. So who else am I going to write about? The law professor they brought in, Harold Coe. We've all had that teacher. It doesn't matter whether it was law school or high school or college. The person who walked in the room, lit it up with their passion, their intensity, their conviction. You wanted to believe more. You wanted to hear more about whatever it was they were teaching. You worked harder for this teacher than anyone else you've ever worked for. For me, that person was Harold Coe, and I wanted to capture him on the page. But more important, far more important, Harold Coe was a son of political refugees. As I said, his father was an activist in Korea and suffered greatly for it, ended up exiled here, and what did he tell his son? Don't cause trouble. Don't be a problem. The nail that sticks out gets pounded down. Work hard, earn your place in the community, and leave it at that. The last thing he would tell his son to do is sue the United States government. So there's a deep internal conflict. Is Harold going to do as his father said, or is he going to do as his father did? And that helps drive the story as well. Lastly, Yvonne Pascal, the refugee. Probably the most important person in the book. Why? We've all seen the photographs in the New York Times of people crammed into boats coming from Haiti. Nameless, faceless, masked. We don't know them. We don't necessarily care. We don't know anything about what they've been through, the trials, the tribulations, their experiences, their hopes, their dreams. I need you to care about Yvonne Pascal immediately from the very first page. You have to know about her children. You have to know about her torture. You have to know about her husband. And maybe if you understand her, you'll care. You'll understand what's at stake in this book. And Yvonne Pascal is a real person. I spent 5 years getting to know her. 5 years trying to get the story from her of everything that she had been through. Who wants to talk about being tortured? Who wants to talk about being told they're HIV positive behind razor wire by a military physician wearing camouflage who looks like just another soldier? Who wants to talk about the guilt and fear about having left their children behind? Yvonne finally showed the guts, determination, and courage to talk to me about these things. And, it was not easy. Can you imagine having to say again, did you say there was blood on the floor when you miscarried? It's horrible. But I wanted to write this thing with the kind of detail you would expect from a novel, and that's what it took. And last thought about characters, the government lawyers. I wanted one government lawyer I could use to describe the other side. Because no one wakes up in the morning and says, I'm going to do evil, right? Everyone thinks that what they're doing is the right thing. And I wanted a perspective, I wanted a government perspective that I could bring in. Big problem. The Clinton administration took over halfway through this case, which is something I'll talk about in one moment, but that meant there was a big changeover in lawyers. So there was no one attorney I could follow the whole way through. And you know, as readers, you don't like getting to know someone and having them vanish off the page. I did the best I could. I talk about Ken Starr in the first half of the book because he represented the Bush administration. And I mentioned several other attorneys, including a very brave guy named Bob Beglighter, who was at the Eastern District of New York as working in the United States Attorney's Office, who got up and made a big speech in the middle of trial in a very uncommon way, basically telling the judge what the government was doing wrong. There was a huge rift between him and the other government attorneys. But there was no one person I could follow all the way through. Difference between novel and real life. Now you know the story, and you know the characters and the plot, and the legal issue at stake. So I just want to finish up with a couple thoughts about Guantanamo today. Because I started work on this book in 1999. And at that time, I thought it would be primarily about the relationship between law and politics and our legacy as a nation, a haven for refugees. But obviously, things have changed in light of 9/11 and what we've done down in our naval base since then. And I now look at the book as a cautionary tale about how we use Guantanamo. If you ask the people who worked on this case 12 years ago, they will tell you, we ran an extra-legal prison camp in secret and without accountability. And great, great harm happened as a result. We did damage to the values that define us as a nation, from individual freedom to the rule of law, and innocent people got hurt. When the Haitians protested in August 1992, that they were being confined, some of them ended up being held in razor wire pens that were fit for chickens. Worse still, military physicians told the INS certain people were not getting proper medical care and had to be evacuated immediately. What did the INS do? They let some out, but others they let languish on Guantanamo, knowing they weren't going to get proper medical care. INS spokesperson Duke Austin told the New York Times, and go check on Westlaw right now, you can find it there, they're going to die anyway, aren't they? This is the United States of America talking. And this was not just the Bush administration. This is not a Republican issue or a Democratic issue. President Clinton, then Governor Clinton, on the campaign trail in September 1992, more or less indicated that he would shut the camp down because he thought it was wrong were he to become president. And what happened when he took office? His advisors indicated to him that it was going to be politically unwise to go ahead and do that. So the camp stayed open. Worse still, worse still. And I'm going to give away part of the ending now because I think this is so important. The students won. The students won a ruling from Judge Johnson, the Eastern District of New York. The Due Process Clause of the Constitution applies on Guantanamo. Yvonne Pascal cannot be treated like an animal. And ultimately, the Clinton administration freed everyone who was on the base. But they threatened to appeal. And so Yale Harold Koh and the students made a deal with the government. There will be no appeal as long as we agree that the lower court decision will be vacated, erased from the books, gone. So it doesn't exist as precedent anymore. Flash forward 8 years later, the Bush administration is thinking about what to do on Guantanamo. This is the memo written by lawyers at the Department of Justice, the Office of Legal Counsel, telling the Department of Defense, telling the White House, you don't have to worry about the Haiti case. It's been vacated. Who wrote it? One of Harold Koh's proteges from the class of 1992 at Yale, a guy who didn't want to work on the case. Incredible irony. Unbelievable. So now we've opened up Guantanamo again. And obviously, it's a different group of people. These are suspected terrorists, but nevertheless, we've only charged a few of them. And even our own government has admitted that some of the people on Guantanamo are completely innocent. There was a big Washington Post article about this just a few weeks ago. How are we going to treat these people? What are we going to do? This is not a Republican or a Democratic issue. Senator John McCain is leading the charge to limit the way we handle people on Guantanamo and at least outlaw inhumane and degrading treatment. And the proposed legislation passed 90-9. 90-9. And one of the 9 senators who disagreed with McCain said, these people are terrorists. And McCain's answer was, this is not about them. This is about us. This is about what our country stands for, what our Constitution stands for, and who we are as a people. I just want to finish up with a thought about Yvonne Pascal and Guantanamo as symbols, because there are thousands of Guantanamos out there and millions of Yvonne Pascals, people who need your help, people who need your talent and commitment. And I hope you all find the Guantanamo that you care about, the thing that's going to keep you up all night, that will make you fight through 3 days with lack of sleep, I don't care what. Because not only does the world need your talent and commitment, but I need the topic for my next book. Thank you very much. Does anybody have any questions? Bored you all to tears. Well, one of the things that people often ask me right away is what happened to Yvonne Pascal. And you know, this goes back to the big question. Tom DeLay led a group of Republican senators who were just furious that we were letting this group of people into this country. And you know, I think that's the wrong question to ask, is what bad thing might happen if they come in. You know, we're a country of refugees and immigrants, and the issue is what contribution are they going to make? The people who are on Guantanamo today, many of them, they work full-time jobs. They're construction workers, taxi cab drivers. They are musicians, they're caterers. Some of the kids are now going to college. And Yvonne Pascal works a full-time job. She's a homeowner. She pays for her own health care. And her older son is serving in the United States Marines and just came back from Iraq. And you may not agree with the war, but if that's not a contribution to this country, I don't know what is. You know? Yes?
Can you repeat again the case in which the due process applying to Guantanamo came out of, and then how you see that due process applying to the current military tribunals in Guantanamo Bay?
The decision came down in June of 1993. 823 F sub 1028 is the site, since I see you typing madly. Judge Sterling Johnson, the Eastern District of New York. What he said is that the due process clause applies because Guantanamo was under our complete jurisdiction and control. The United States government is purely a creature of the Constitution, and to the extent that we operate anywhere, the power comes from that, and the constraints therefore come from it as well. I am not an expert in constitutional law. You know, I'm a writer, not a law professor. It seems to me that that Judge Johnson's argument is pretty strong, and you know, the Supreme Court has followed up in the recent Rasul decision, talking about the fact that Guantanamo was under our complete jurisdiction and control, and therefore there ought to at least be that you at least ought to be able to file a habeas petition. And now, obviously, the question is, what rights do you have? It seems to me absurd to say is the government is now saying that you can file the habeas, but you can't actually complain about anything, so it's just like this empty formal exercise. It seems to me you ought to at least have the right to a lawyer and at least have the right to challenge your confinement in court. And I'm most comfortable with a federal judge, but I can't get into the great, the issue about the military tribunals and whether or not that's the best forum for that. Frankly, Professor Chris Schrader is here. I'm sure he's got deeper insights on that than I do.
You've done a great job summarizing where we are. Rasul did not decide the constitutional issue because they found a statutory basis for the habeas petition to be properly heard. And now, as you say, the government is acting as though there was a right to habeas, but no rights under habeas to be challenged. And those issues will work themselves back up to the Supreme Court.
Yeah, we should be getting a decision from the D.C. Circuit on the extent to which the Constitution applies, and specifically the Due Process Clause, sometime in the next few months, I think. Anybody else? Yes?
You were saying that before Guantanamo became news again, you thought of this book as kind of a law and policy type thing. And I was wondering if you could talk about the difference between sort of, military law and civil law as far as the issues of the Constitution applying to Guantanamo, given that we are in a war.
I don't know much about military law. I spent 6.5 years focused on how the Constitution applied to the refugees on Guantanamo in 1992 and 93. And I am as curious as you are about how these issues are going to be resolved. I'm not a scholar in military law. If anyone wants to add to that, I'm fascinated to hear. And one of the things I do when I come to these and give these talks is I figure I'm going to learn as much from you guys as you're going to learn from me, because some of you presumably have been studying some of this stuff in class. Anybody? Vast silence on that. Yes, as long as it's not about military law.
I'm curious about how working on the case affected the kinds of work that students do at Yale on human rights type issues, and any lessons or experience that you might have from people at other schools potentially interested in starting similar types of projects.
I think the case had a huge effect, and several different ways. First of all, it greatly affected the people who worked on the case, and a lot of them are now full-time human rights lawyers or law professors in the field. A couple of examples: Mike Wishney at NYU, Sarah Cleveland at Texas, now visiting at Columbia. Yale as an institution, they had already had an international human rights clinic, but it focused on Alien Tort Claims Acts. For example, some military general from Guatemala would torture somebody in Guatemala, and then they would file an action against this person in the United States court, and the guy wouldn't show up, and he'd get a default judgment against him. So it was primarily norm enunciation. Rarely were they able to get damages. This case ratcheted up the stakes tremendously. And there was a bit of trepidation at first, because Coe and the students filed the case there were no sort of like institutional channels they went through first and said, we're about to take on the United States government, is that okay? They just did it. And after the fact, with the Rule 11 motion out there, they had to go tell the dean. And to his great credit, he said, and there's a scene in the book, it was Guido Calabresi, now a judge on the Second Circuit, and he's, Harold, what is our exposure? Over and over again, he kept asking. But he and the school backed the students and Coe up completely, and spent ultimately tens of thousands, if not hundreds of thousands of dollars on this action. And the Lowenstein International Human Rights Clinic has become a whole lot more, I think, aggressive and involved as a result of this case. But the other thing is that it wasn't even a clinic case to begin with. The students cooked this thing up on their own. It was not part of any formal academic structured thing. They simply showed up and told Coe, we want to sue the Department of Justice. And away they went. Anybody else? Yes?
Were Coe and the students afraid that the district court would be overturned by why not
Yes.
let the government?
Yes, thanks. They were afraid. Harold was quite sure at the time that if this case had gone before the United States Supreme Court, they would have lost. and they would have ended up with horrendous precedent, and they thought the lesser of two evils is to go ahead and make this deal. There's a funny little asterisk to all of this, which is that when Coe was trying to decide whether or not they would go ahead and take the deal, he got a call from someone at the Department of Justice. And this guy at DOJ said something to the effect of, October 10th is the deadline, you have to decide by October 10th, click. I was thinking, why October 10th? And you know, it ate at him. And finally, one day, a librarian was dropping off, you know how the reporters, after the bound reporter comes out, like the soft cover ones get thrown away, they're the ones in the library. She gave him the soft cover version of something that he'd been waiting for, and all of a sudden it hit him. He called the Westlaw people, the publishing people, and he said, October 10th, is that, you know, if I agree to vacate something by October 11th, you know, for this particular case, will it be in the hardbound volume, you know? And what the person basically told him is, if he did it before October 10th, the opinion would be erased from the hardbound volume. It wouldn't be there. It would be as if it never existed. So he called up and made the deal 2 days after the deadline. And if you go to 823F Sup, 823F Sup, page 1028 today, in your library, you will see the case, and it doesn't even say vacated on it, because it was too late. So it was a moral victory, but Harold really wanted it on there. And they still, people who are fighting the Guantanamo cases today, still cite this case, and they cite it. They say it's vacated by agreement, but they say, you know, we're citing it for the force of its reasoning. You know, whatever that may mean. Anybody else? Yes.
Yeah, were you able to obtain any information from Ms. Pascal as that how she survived, considering the state of her health, being that she was HIV positive without any medication the entire time she was detained at Guantanamo?
Well, she did get proper medication after a while. The Haitians were given AZT, but you know, many of them were HIV positive but had not reached the stage of full-blown AIDS. The problem, and Pascal had a low T cell count, which is one of the key measures, but she was okay during the year she was there. I mean, frankly, it could have been much worse because she went on a hunger strike. She led a hunger strike, sort of exactly what's going on today, right? Among many of the Haitians, and she lost 30 or 40 pounds. She was a stick figure when she was finally released. And Harold and Michael Ratner, who was another one of the key lawyers involved, were really afraid she was going to do something terrible to herself, if not just plain kill herself. But the Haitians were getting AZT. The problem was this. There was no, there was no meaningful doctor-patient relationship. These people were being held in captivity, behind razor wire with guard towers. They didn't trust the physicians because they were dressed just like the rest of the military. And you don't trust the military in the first place if you're from Haiti, because you grow up being absolutely terrified. Every time a soldier walks through your neighborhood, you run in your shanty and duck because you just don't want to take a bullet in the head. You know, nothing's ever going to happen. The person's just going to shoot you, and that's going to be the end of it. So a lot of people had the AZT, but they wouldn't take it. They were afraid they were being poisoned. And so when the students first came down to meet with their clients, the clients all came up to them with these pills, and they dropped them on the table like Halloween candy and said, you know, look, they're trying to poison us. You know, my God, what are we going to do? It was an absolute nightmare. In fact, I think this is a good moment. Hiroki, why don't you run? I just want you guys to see 1 minute of what we're talking about when I describe this camp. I've never actually shown this video in public before, but I thought you guys have a great AV system, and I think it would pay for you to understand exactly what we're talking about. This is August 1992. Before, don't run this for a second. I'm going to say before a, there were different military commanders, and the detention camp was run very differently depending upon who was in charge. Chapter 6 includes a discussion of an incredibly noble guy named Stephen Kinder, who was in the Army. And he got it. He understood that, you know, the Haitians were not our enemies. And during the 3 months that he ran it, there were almost no problems at all. And no one was happy to be there, and he wasn't happy to have to do this. But there was no violence. What you're about to see is what was the case several weeks before he arrived, though. And this is after a Haitian demonstration where they were pleading to be released. Remember, these people haven't been charged with anything. They proved that they deserve asylum in our country. And their only quote-unquote crime is that they're HIV positive. This is what we did. Thanks, Hiroki. That gives you an idea. You can kill it now. Yeah. I can't hear you, I'm sorry.
Did students pursue any international human rights violation claims because of the treatment in Guantanamo? And the next question is whether people like Ms. Pascal got any type of monetary relief for their violations or as part of the settlement?
The first question, were there any international law claims? Yeah, but they weren't a focus in this case. There's actually a second case in the book that I haven't talked about here at all because I don't want to get everyone all confused about the different things at issue. But I'll raise it now for 1 minute so everyone understands. After 35,000 people had left Haiti, the Bush administration decided it had had enough. And the U.S. Coast Guard began intercepting every Haitian boat and sending everyone straight back to Port-au-Prince without giving anyone an opportunity to prove whether or not they deserved asylum. So people were basically locked inside Haiti. It was like we put up a floating Berlin Wall around the country. And the charge is that this was a violation of Article 33 of the United Nations Refugee Convention, which says you can't return people to a place where they could be persecuted. Now, if you think about it, if we can do what we did there, you could do the same thing, that we did prior to World War II, and it's perfectly legal. Just return Jews to the gas chambers in Germany. Just return political dissidents to China, where they could then be tortured again after Tiananmen Square. Well, the United States Court of Appeals for the Second Circuit said this is absolutely illegal, and they ordered the Bush administration to stop. And the case went to the Supreme Court, where Harold Coe found himself 1 year after filing the case before his former mentor, Harry Blackmun, arguing for the very principles that brought his father into this country. And what did the Supreme Court do? They ruled 8-1 against the Haitians. They basically, and I get into the whole idea of Justice Scalia and plain language in this case, because the plain language was absolutely in favor of the Haitians in Yale. It said, "Thou shalt not return." And the Supreme Court looked it straight in the eye and said the word return doesn't mean return. And the whole question is, if you're going to be a plain language person, well, follow plain language. But they didn't. They didn't. And I looked at the notes. When Justice Blackmun died, you could go look at all of his notes at the Library of Congress. There, during the conference, Justice Souter and Justice O'Connor had said to Blackmun, and he, at least based on his notes, well, the statute in its terms is clearly in favor of the Haitians, but we can't possibly vote this way because of the way it's going to crimp presidential power. Unbelievable, but true. And the second question, there was no attempt to get monetary relief. They didn't want to screw around with that. They just wanted, the point was to get them off the base and get them proper medical care. And they just left it at that. They didn't go any further. Anybody else? Yes, and then you.
I'm curious to know how difficult it was to obtain information that you detailed in the book from the government, considering they managed to get the case vacant from the books.
It was very easy because I had all the documents from the case. Yale and Simpson Thacher had tens of thousands of pages of legal documents and dozens of videotapes. And I interviewed a lot of the Haitians, and I interviewed all the students who'd been down there and the lawyers, and then some of the government lawyers who would talk to me, and then government policymakers as well. One of the most important ones was with Sandy Berger, who was later National Security Advisor, and at the time he was Deputy National Security Advisor. And what he told me was this. It's just an astounding moment. The Clinton administration wanted to lose the case. They knew what was going on was wrong, but they wanted political cover. And so they sent the lawyers back to court basically to lose. But the lawyers didn't know that that's exactly what was going on. They just got no high instructions from the Department of Justice. Under Bush, the White House was calling and practically dictating legal policy because they were so concerned about it. Under Clinton, they just left the lawyers out there on an island and basically let them litigate the case, not really knowing what in heaven's name was going on. And later, Berger said, this is a quote, it's in the book, "A lot of people were glad when we lost that case. I was glad, the president was glad." And Judge Sterling Johnson, who you ought to be able to see, C-SPAN is going to run a special on the book like in a week, and Judge Johnson is talking in it. It was filmed at Yale like 3 weeks ago, and he's an incredible character. You really should see it just for him. He went down to the Rose Garden, and he met President Clinton during some ceremony. And The White House counsel, Bernard Nussbaum, whispered into Clinton's ear, this is Judge Sterling Johnson, the guy who ruled in the Haiti case. And Clinton's eyes just lit up. Is that right? Shaking his hand just up, and it wouldn't let go. He never said a word about the decision to Johnson, but he just acted like they were best friends. You know, amazing. Yeah, you had a question. You, yeah.
I wanted to know, in your books, how, I know you narrowed it down to kind of one legal issue. How did you present the arguments on either side of whether or not due process and the Constitution applied to these refugees in Guantanamo? How did you present those arguments?
I relied on court transcripts and the arguments the students had among themselves. You know, and I sort of try to do it in the form of dialogue, narrative, and discussion as much as possible. I avoid, as best I can, kind of legal treatise-y writing at every stage. And it's really, you know, tricky when you want to, I had to like write something about Racejudicata, because you have to understand there was actually something I haven't mentioned to any of you is, and this makes the case even that much more unbelievable. A bunch of immigration experts brought a case on behalf of the Haitians before the students, and the immigration experts got their rear ends kicked. They lost. In the 11th Circuit, they did the best they could. They had the finest immigration experts in the country. Ira Kurzban, an absolutely brilliant lawyer from Florida, who brought the case, and you know, they managed to sort of slow down the interview process for a little while because there was a big complaint about how the interview process was being done. But the case ends up getting kicked out, and one of Coe's great questions was, isn't there res judicata here? We can't bring this case again. And you know, I had to sort of weave that in a discussion the students have with Coe. You know, talk about perfectionism. I rewrote that thing 100 times because I need all of you guys as people from the legal community to buy it, to think it's sufficiently like accurate and authoritative that you know, you're going to buy into it. But I can't lose the general reader. And you know what it's like when you're telling your parents what you're studying, their eyes glaze over. It's a nightmare. So, and it's one of the reasons this book took so long. It used to be 1,000 pages long. Now it's 311. You know, and I don't know if the bookstore people ever showed up or not. If they are here, I will let you know. I don't know how much they're charging, but I know what it's like to be a law student. If it's over $25, I will pay every extra dollar and cent for each book. So I actually end up losing for each book you buy, but I don't care. Because you know, I've spent 6.5 years of my life writing this thing, and I want people to be able to read it. So, you know, to the extent anyone feels like getting it. Anyone else? Well, thank you very, very much. I really appreciate your time. And the last thing I'll say is, as you're leaving,